I see about 40, 43. We're expecting 57. All right, so we can start and then continue from where we ended last week. We're supposed to meet on Thursday, but there was an emergency, so we had to reschedule it to about 8 p.m. But later on, when I had the news that it wasn't going to be favorable, we had to postpone the class to another time. So hopefully, maybe we'll see. I mean, following from what we will do today, and then we'll see when it will be possible for us to meet again. All right. So as we always do, please, if you have any questions concerning your readings and then what we did last week. Last week, we were able to at least recap on what we have done so far from the day one up to the contract or law of contract, what we have done concerning the vitiating factors and then discharge. We have given you a lot of materials, including cases for you to read concerning the topics that we have done so far. So through your readings, and then also there were also some recommended cases and readings for us to do. So if you have any questions following that, you can bring your question forward and then we'll look at it. But we'll do that in a jiffy because today, as I informed you, we have a guest lecturer who will be joining us very soon. Once he joins us, we will give the class to him for him to take us through. All right, so let's have the first question from Emmanuel Ade.
Hello, sir. Good
Yes,
evening
sir.
from my end here.
Okay.
Sir, so I have a question with regards to the cases that you gave us to read. I mean, the course web sent some cases that was given to you.
So which of them?
So I am picking two. I have questions for the two, which is Alasa Kotokoli versus Moro Hausa, and also.
Okay, Emmanuel, you know what? For those cases, I asked you to read in preparation of today's class. So
Okay.
you can hold on to those questions if those questions are in reference to those cases, because as we discussed today, well, maybe our guest lecturer will be able to hammer on those areas. And then you can also bring your questions forward because those cases are related to the topic for today. Do you get me?
That is okay. That is okay, sir.
So if it's about that, then you hold on. But before that, the other ones I was asking in reference to previous studies or maybe previous topics that we've had in class.
Yeah,
Okay.
sir. Just a quick one before the other my other
Okay.
colleague will
Go
come.
ahead. Go ahead.
For those of us who were unable to attend the on-site lectures, and
Mhm.
you mentioned that you'll be teaching us how to answer questions because we are
Oh, we'll do
trying
it. We'll do it.
Okay.
We'll do it. We were supposed to do that on Thursday. It didn't come, but we'll do it. We'll do it. Don't worry about that.
And lastly,
I have
the
you in
course
mind. We'll do it. And
your
that
course
was
outline,
shared,
sir.
or
No, it has not been shared.
that was shared. Oh,
It has not been
okay.
shared.
I'll confer with Michael and see, and then.
Okay, sir. Thank you.
Okay. Thanks for the reminder because I thought I shared that one with you. All right, Eunice. Can we hear
Hello,
from you,
sir.
Eunice?
Please, yes, sir. Good evening.
Okay. Good evening.
Please, my question has to do with Balfour versus Balfour, then merits versus merit. So,
Okay.
I learned that intending to create legal relation is also part of a valid contract. But after reading these cases, I realized that the court concluded that their contract was not valid. So, I don't get that side. But since intention to create legal
Come
relation
again.
is
I don't get you. Which contract was not valid?
the
Which of
cases
them?
of
Which of them? Take one of them.
Balfour,
These are two different cases. They have two different outcomes.
yes, Balfour
So
versus
which one?
Balfour.
Balfour versus Balfour. You said it was held at what?
Their contract is not a valid contract. It's not legally bound.
Yes. Yes. Why? You are supposed to tell us why.
So
Why do you
that's why I'm
think that
asking
was...
why.
No, but it's in the case. I mean, before they will come out, make that decision, they would have explained the point. It is because they are married, they are couples. Bafo and Bafo, they are couples. And there's a separation. So what was it about? Can you give us the fact?
Yes, it seems one
You should be able to give us the
yes,
fact, yes.
they were couples, yes, and
Uh-huh.
one was it seems both of them were living at a particular country, and the husband left
Mm-hmm.
for some project or something, and he told the wife that he'll be giving him some kind of money at the end of the month, but
Mm-hmm.
later on the husband didn't perform what he said, and
Yes.
they ended up the husband said because of their separation, he said they should go for divorce.
Yeah. So
Something like that.
the fulcrum of the matter, or the main factor, that they were married and there was a separation at the time. That's not a material fact. But the husband promised to be paying and be sending a woman some money, right? So the
Yes.
legal issue here for determination was the husband's promise a legally binding contract, or was it a mere arrangement? Oh, you see, because between couples, sometimes some of these things are mere domestic arrangements. They are not legally binding contracts. Do you get it? So
Yes,
that
sir.
was for the court to decide. And the reasoning was that agreement between spouses are generally not intended to be legally binding. And I explained this in class, remember? So agreement between couples are most of the time they are domestic arrangements, and they are not intended to have any legal bind. So they are not legally bound to, or you cannot enforce those contracts in court.
Oh, okay.
So the reason why the outcome was that they realized that there was no evidence that the parties intended to enter into a legal contract. So that is why the intention to create legal relation is very, very important. Because if you don't have that intention, so they'll look at the intent. If you are living with your husband, Eunice, you are living with your husband, and you promise your husband that you will give him some money, okay, and that money did not, you did not give him the money. Can the husband sue you in court demanding the payment or demanding that particular money? You get it?
No.
Uh-huh. Because it's just a domestic arrangement, domestic arrangement. So that was what happened. But that is why I gave you those two. Married merit or married versus merit. That one is a different, okay, it had a different outcome. The facts are not the same as Balfour and Balfour. So I don't know if you want to tell us that one as well.
Yeah, it's okay. I also have another
In this
question.
case, Balfour and Balfour, in this case, they were not married. Or they were married. But in
They were
marriage merit,
married.
they were divorced. Have you seen that?
Yes.
Uh-huh. You said what?
I have another question.
Oh, you don't want to explain the opposite one. You don't want to explain the two for us too.
So it's okay, you've already explained to me.
Okay. All
So
right. So the
my
other
second
question is what?
my okay, can an individual sue a company over a contract that was made between its employees?
Come again.
That is
Can an
maybe
individual?
the can an individual sue a company over a contract that was made between its employers and the individual. So I don't know whether you are getting my
So the
question.
individual is an employee of the company.
No. The individual is not an employee of the company. He just did a
He's a
contract
third party.
between. Yes.
Is he a party? Is he a party to the contract?
Yes.
The individual is a party to the contract.
Yes, sir. But
So the company,
the contract was made between the employees, but not the company.
So the individual entered into a contract with the employees of a particular company.
Yes, sir.
Yeah, and so once it's not the company and it's individuals, so you can enforce it. So I don't understand. Your question is, can the individual sue the company? Is that a question?
Yes, over a contract, yes, that was made between
the employees and that particular individual.
Yes,
If
sir.
if the employees were acting on behalf of the company, then you sue the company. You get it? But if they were not acting on behalf of the company, but doing it on their own behalf, then I don't see how the company will come in.
Oh, okay, but I was just
So
maybe because of their
an
parts.
example is I'm an employee of GCTU. So you know, if you have a contract with me, it just on individual basis. Yeah, understand? It has nothing to do with the company. Oh,
Okay,
is
sir.
that not your question?
Yes, sir, that's my question.
Uh-huh. So if the individuals are acting on behalf of them, so we'll talk about agency very soon in one of our lectures, and you'll see how some individuals or persons can act as agencies for some companies and other principals. Okay, we are not there yet. But once you enter into contract with individuals who are not acting on behalf of the company, but acting by themselves, then the contracts are enforceable against the individuals and not against the company. Do you get it?
Okay, sir.
But there are some officers of a company you don't worry, we'll get to a company, we'll do some company law, probably maybe next week. So you'll get to understand that there are some officers of a company who almost all the time they act on behalf of the company. So when they enter into a contract, it is assumed as the company going into those contracts. And you also get to understand when we get there that companies are legal entities. They can sue and be sued on their own. So even when it happens in such a circumstance, you don't sue the individuals, but you rather sue the companies. Do you get it? So
Yes, sir.
hopefully, when we get into company law, you understand some of these things.
Okay, thank
All right.
you.
Yeah, you're welcome. Any other question, please? Any other question? All right. So the arrangement was that today we'll continue with another area of law called tort law. Tort law. And under tort, it's unfortunate that you said you've not seen the outline, but if you look at the outline, we are supposed to look at negligence. Negligence is one of the most important concepts in tort law. We'll look at how you are supposed to be responsible as a business owner, as a business owner, yes, maybe, or an officer of a company. You are supposed to hold some responsibilities. Okay, where you are irresponsible or where you are thoughtless, okay, or you are careless, then you may fall into negligence. And negligence, it causes a lot of damages. So there are some economic losses that may come, and there's a lot of damages that may fall on you as a business owner. And so for a reasonable person or a reasonable business owner, there's some right or there's some duty of care that is bestowed on you as a business owner. and you need to ensure that you uphold those kind of responsibilities, because your failure, like I said, may cause a lot of harm to another person or to another company. And that is the topic for today. So we are looking at the meaning, and then we'll look at the element. Such law always involves some elements. Okay. And so please, just as I told you, I am pleased to inform you that we have our guest lecturer who has joined us now. Please, I want you to take some notes, please. Today, no sleeping, okay? Everybody must be attentive to the class and to our guest lecturer. And then you take the notes. I've already given you some of the cases and some of the areas to read. I'm very sure he will tackle all those areas. If you have any question, just as Emmanuel was earlier wanted to ask questions about those cases, you can bring them on board, and I'm very sure that our guest lecturer will answer them for us. By the end of the lecture, you should have made your notes concerning negligence, and then those notes will help you prepare very well for the exams. On that note, I want to introduce you to the class, a man who is almost is at the edge of becoming or being called to the bar. He's a business owner. He's a journalist, and he's a whole lot. You get to know him. So I'm pleased that he has accepted to hold this topic for us today. I'm pleased to introduce to the class Mr. Sadiq Adams. Senior, if you are here, you can take on from here.
Okay. Good evening, class.
Good evening, sir.
Am I
Good
am I
evening, sir.
audible enough?
Yes, sir. We can hear you.
Thank you very much. And it's a privilege to be with you, to having gotten the communication that you are such a very vibrant class and you interact very much. So I have to brace up and prepare to have an encounter, a very short encounter with you today. And like he's already mentioned, it's a very important topic in the law of torts. And I'm sure that as you have it on your course outline, many of you may have seen it already. So we will not belabor the point of going into what tort is and what it's not. But we will have a very short and I believe very interactive section going forward. So that will be for my introductory remarks. If there is anything to say before we proceed. Hello.
We can go ahead. We
Okay.
we are ready for you.
Doc, we can hear you, please.
Okay, thank you. So we will spend a very short time in treating this, but that is not to say that the topic is not important. For students of law, one of the most important topics under the law of torts. So when we say the law of torts, tort simply means a wrong. So it's not an English, it's just an English word that has been coined, but tort in its distinct meaning is wrongs or somebody having wronged you. So it's the law of torts. But there are so many elements, or there are so many causes, there are so many topics under the torts law of what we have already defined. But then one of the most important is negligence. In law, we call it the general negligence. But as business students and not wanting to delve too much deeper into what may not be necessary, we will just stick to negligence. So before I start, I'm sure this is an English word, not to go into the legalities of it. Many of you may have heard negligence. He was very negligent in this. What comes to mind? Don't be too much into the legal effect or aspect of it. When you hear he was very negligent. What comes to mind? Yes.
So Obama, you are welcome.
Thank you very much.
So, okay. So basically, it has to do with something that should have been done, which was not done, and as a result, has led to some kind of damage, so to speak.
Right. Thank you. On what they understand when somebody says, "Oh, he was very negligent." Yeah, face.
Hello.
Yeah, Faisal, you can speak.
My understanding to negligence is doing something without the intended purpose.
Fine. I can see Paul. We take the last one. Paul.
Okay, thank you very much. And I think to my side, it is someone who has been careless and it sometimes cause harm or a problem.
Fantastic. So you basically have an understanding, all of you, what means when somebody says you have been negligent. And like Paul said, somebody was careless. That's exactly what we understand when we see negligence in its strictest or basic terms. But in law, when you say negligence, it is not just being careless. From our basic understanding, you are careless in doing something that ought to have been done in a specific or proper manner. But in law, when you say negligence, I want you to take into a very important account that negligence in law means that I've done something, that thing has caused damage to someone. And in doing so, you breach a duty that you owe to that person. And not just breaching the duty, there was a standard for you to have done that thing, and you did not go by that standard. So negligence is not just a demonstration of or proof of heedless or careless conduct. For negligence to arise in law, there are three elements that must be present. And in answering any negligence question, these three elements do not appear in your answer, you are not right. I will not say you are wrong, but you are not right. And if you are not right, you do not get the marks you deserve. For the three elements, duty of care must be. So you can write duty of care must be owed or duty of care. Then there is a breach of that duty. And the breach resulted in damage. These three are almost always constant in every negligence question. So for somebody to succeed in an action in negligence, you see somebody has been negligent, you go to court and you want to succeed.
Sir, please, can you go over the key words again?
Yes, I'll go over, Afreda. So these elements must be present. Duty of care. Then there is breach that duty. The last one is the breach resulting in damage. So those of you who like shortening your notes, duty of care, 1. Breach of duty, 2. Damage, 3. These are the elements or factors that must converge for there to arise a cause of action negligence or for you to succeed when you claim that somebody has negligently done something. Are you all right?
Yes, please.
Yes,
Thank
sir.
you.
Yes, sir.
Okay. So convergence, in trying to explain all this three together before we proceed, we are saying that walking by the roadside, a driver has driven on the roadside, and me is on his bicycle. He has hit me, and me wants to bring an action in court for negligence. He must establish that the driver owed him a duty of care.
So Obama,
And
can you please position yourself a bit because we barely hear what you're saying.
is it better now?
Yes, it's okay now.
Is it better?
Yes,
sir.
it's very clear
Yes, sir.
now, sir.
It's okay now.
Okay,
Thank you.
Yes. So I'm saying that in trying to understand what this element mean, let's say, for instance, you are riding a bicycle by the roadside. A driver has come to drive on the pavement and hit you. You have fallen down, you have sustained injuries. To succeed in an action in negligence against the driver, what you have to establish is that the driver owed you a duty of care. That duty has been breached. And the duty being breached, the result is that damage has been caused to you. So the duty of care, breach of duty, and resulting damage that must be present in your case is what we are about to explain. So duty of care, the first element, duty of care. I want you to put down this case of, when you say negligence, the most significant or landmark Ghanaian case is the case of Alassane Kotokoli versus Moro Hausa. Alassane Kotokoli. Alassane is Allassan. Alassane Kotokoli. And the versus is basically end. So Alassane Kotokoli versus Moro Hausa. Moro is Morohausa. Hausa. That's established negligence in Ghanaian courts, or the landmark case in Ghanaian court when it comes to the establishment of negligence. Yeah, I think someone's hands is up.
You go first.
Obama, thanks. That's me again. So I want to get a clarification. So main elements need to be prevalent for us to say, indeed, there has been negligence, right?
Yes.
Which is the duty of care, breach of that duty of care. And then the breach has led to a damage.
Yes.
I want to find out, is it possible that the duty of care, which has been breached, if it doesn't lead to a damage, is it a case that we cannot say that there's been a negligence? Is that the case?
It is almost likely or unlikely for a plaintiff to succeed when all these three do not suffice or converge. You have to get all the elements to prove. So in law, when we say elements, you have to prove all elements. Even if one of them is not proved, it is unlikely that you will succeed. That is why I said in law, negligence is not just somebody has been careless. You have to prove all this to be able to succeed in that action. So if one of the elements is unable to be proved by the plaintiff, that is the person bringing the action, or the person who says they have been wronged, they will not succeed, or very unlikely to succeed. Is it
Yeah, thanks very much, Obama.
right? So we can proceed. Then go to element number 1. Duty of care. How do you prove duty of care? In proving duty of care, what you must advert your mind to the facts when somebody says duty of care. It means that any reasonable proximity between two persons or properties of two persons, one of them will owe a duty of care. The proximity here does not mean you are closer to me, or I am closer to you, or our houses are closer, or our cars are closer. No. The proximity here in basic understanding is that If you produce sachet water, if you produce bottled drinks, if you produce food by the roadside, anybody who reasonably will come to buy the food, whether they are from Wa, whether they are from Tamale, or they are from Axim, they are not closer to you where you sell the food in Tesano or where you sell the food in Alajo. They are not closer in terms of proximity. But reasonably, it is foreseeable that even if they travel from Techiman to Accra to buy wache from you, you owe them a duty of care to make sure that you prepare the wache by the standard sets. Please, do you understand?
Yes, sir.
Okay. Is
Please,
somebody's
sir.
hands
Yes,
still
sir.
up?
Yes, sir.
Okay.
So, sir, just a quick one. So, with regards to what we are treating now, looking at the case between Alasan versus Moro Hausa and Ano, which is the company, and also the case between the Ghana Highways versus Mensa. So, I want to ask, where do we draw the line between personal risks and duty of care or duty? I mean, a duty of public duty, sorry.
I want us to take our time to establish the understanding before we go into the cases. That is why I keep on mentioning the cases.
Very
Is
well,
that very fine?
very well, sir. Very well.
If we go into the intricacies of the cases without understanding the elements, you need to know the elements. Sometimes the cases are important, but if you know the grasp of your elements, the foundation, it is very easy to know that this case is negligence, this case will not succeed. So if we take our time, I'm sure that when we get into the intricacies of the cases, we'll be able to understand them very well. Is that okay?
Very well, sir. Thank you.
Right. I saw another hand up.
Hello, sir.
Yeah, Eunice.
Please, can you go back with the explanation again, the duty of care?
Okay. So when I say duty of care, in simple terms, it is the legal obligation to take reasonable steps not to cause foreseeable harm. Like you have an obligation to take steps in whatever you do, not to cause harm to another person or another person's property. Anything that you are doing, you take reasonable steps and care not to cause harm to another person who is foreseeably or who is in terms of foreseeability within the range to be suffered or who will suffer from your actions. That is basically the duty of care. So I was using the example of you preparing, you are a sachet water producer. It doesn't mean that the water you produce will be consumed by people in your locality alone. Anybody who is likely to drink that water, you owe that person a duty of care, meaning that you have an obligation to use the proper standards in producing the sachet water. The best example we can use in understanding duty of care is the case of Donohue versus Stevenson. I'm sure you have it on your outline.
Yes, please.
It was given to
Great.
us. Yeah.
So Donohue versus Stevenson is a 1932 case where a lady has just gone out with a friend and the friend bought a drink. The drink was in an opaque bottle. Let's say you've gone to a pub or you've gone to a spot, your friend invited you out. The friend bought the drink. And then in consuming the drink, you have one last or two gulps to finish the drink. Then you realize that there is a rotten substance in the drink, a snail, rotten snail in the drink. But because the bottle is opaque, you could not observe or you could not identify that something rotten was in the drink. And once you found out, you felt some, gastric sickness all of a sudden because you've taken a drink that contains a rotten snail. you feel very nauseous, you feel very bad, and you have sued the manufacturer or you have sued the owner of the pub where you bought the drink from. But the owner of the pub says, you did not buy the drink. Your friend bought the drink. And in the past, to succeed in an action for duty of care, there has to be a contractual relationship between the person who is buying the drink and the shop owner. They have the contract. So they are saying that if I buy a drink for Paul in a pub and he notices that there is something bad in the drink, Paul cannot bring an action unless the person who bought the drink for Paul. But in Donohue versus Stevenson, Lord Atkin explained that duty of care will be expanded to include people who you should have in your contemplation, that if somebody comes to your pub to buy a drink, whether they bought it or not, they are the people who you owe a legal obligation to once they have consumed the drink. So the duty of care is not owed only to the person who bought the drink. So that initial or original position that the person who bought the drink is the one who is supposed to sue. And if they don't sue, the one who has consumed the drink, despite not being the one who bought it, cannot bring an action. So in Donohue versus Stevenson, the duty of care concept was expanded to include people that you ought to have in your contemplation, that if two people come to your pub to drink, it is not only the person who bought the drink, but the person who consumed has also suffered from your breach. You had a legal obligation to make sure you produce drinks that go through the standard set for how drinks should be produced so that anybody who consumes does not suffer a damage. So duty of care is owed to anybody that you should have reasonably foreseeable that your action can harm them. So if you are a driver and you are driving by the roadside and you hit someone by the roadside, you should have them in your contemplation that this is the road, this is the pedestrian walkway. If I drive on the pedestrian walkway and I drive carelessly to hit them, you owe them a duty of care once you start your car. Once you prepare food, you owe them a duty of care. Anybody who consumes the food, because once you sell, there is a legal obligation under you. If you are in a classroom, the school owes you a duty of care to make sure that the classroom is safe for you to sit and learn. If there is a breakage or there is a cave-in and it kills students or it injures students, the school has a duty of care to make sure that their premises is safe. It doesn't mean only the students. So it was expanded to include people that you should have in your contemplation. If you are doing anything, you should have in your contemplation that anybody that your action can foreseeably and reasonably injure or cause damage to or offend, you owe them a duty of care. Please, do we understand the duty of care from a very practical sense?
Very well.
Yes, sir.
Yes, sir.
Yes,
Very
sir.
clear, sir. Very clear.
Very, very interesting.
Right. So if you are a pure water seller, Lord Atkin in Donohue versus Stevenson is saying that proximity in the definition of duty of care does not mean they are closer to you. Somebody can come from Tamale and buy a pure water in Accra. If there is a substance in it and makes them sick, you cannot say you are producing in Tamale and their proximity to you is not close. You owe them a duty of care. That is the meaning that you all have to understand before you even go into the law. Is about mostly common sense. If you understand the basis, you can identify that this is a duty of care that was owed or a duty of care that was not owed. The key, yes, yeah, I can see a hand up. Is it Ken?
Yes, sir.
Yes,
Good
please.
afternoon.
After.
Sir, please, there's a little confusion in my mind I want you to demystify. So, sir, if a driver is driving and then there is a pedestrian who is walking, but the person is a drunkard, he's drunk.
Okay.
And unfortunately, he causes, because he has drunk, he make the driver cause an accident.
Mm-hmm.
Does it mean that the pedestrian also owe a duty of care to the drivers on the road, or is only the driver who is in the machine, the car, who this rule is binded to?
We will come back to a very, at the tail end of this lecture, we will come to a topic, and this one will come out very clearly. It's called
Okay.
defenses in negligence. So it's a very valid question, but keep it at the end of the
Right.
lecture. You will come to appreciate, or you'll be demystified, so to speak.
Right, sir. Thank you.
Okay. So now we all know duty of care. And in the case of Donoghue versus Stevenson, like I've said, the principle that was developed by Lord Atkin, that all of you must know, try and make the notes after the lecture. Maybe because of time, you will not be able to read through extensively. There is a very important concept or principle in duty of care that anytime you see a question on negligence and you want to establish duty of care, you must have in your answer. It is called the neighbor principle. Neighbor principle. I've already told you that before the case of Donoghue versus Stevenson, before the lady who took the alcoholic drink or the drink that was contained in an opaque bottle with a rotten snake, before that case, only persons who could had contractual relations, and the person who bought the drink. So if you, before that case, if you go to a cinema with your brother and you paid the ticket and something bad happens to your brother in the cinema hall, unless you, the person who bought the ticket, you are attending a Stoneboy show or a Shatawale show, you have paid you to enter the stadium, but you bought 2 tickets from Stoneboy's agents and you gave one to your brother. If anything happens to your brother, they could not sue to succeed because they did not have any contract with Stoneboy or Shatawale's team. And unless you go to sue, so your brother can get injured, he may be beaten or he may fall into a pit at the venue. He cannot sue because there's no contract. He did not buy the ticket. But after the Donoghue case, your brother could sue because Stoneboy and his team or Shatawale and his team should have had you in their contemplation that if you buy 2 tickets, you cannot go alone with 2 tickets. They should have in their contemplation that somebody else will come with you and they should protect you as well, or they should make sure that they owe a legal duty to you. So after Donoghue, anybody at all can bring an action, even though they are not contracted to the person whose action has made them suffer a damage. Please, do we understand this?
Very well, sir. Very well.
Yes.
Okay. So the neighbor principle is that I'm sure all of us know the Bible and we know who our neighbor in terms of the Bible. The Bible is saying that you should treat your neighbor or love your neighbor as yourself. We all understand that. And Lord Atkin is saying the previous position of the law should not hold. The new position is the neighbor principle. And Lord Atkin is asking, when we say in law, who is your neighbor? He says your neighbor in law is anybody or any person that you should have in your contemplation. Anytime you are doing anything, you should think that your action can offend this person. When you think that your action can offend this person or your action may offend the person, when you are directing your mind in doing something, that person is your neighbor. When you are driving, the pedestrian is your neighbor. When you are preparing food to sell, the buyer is your neighbor. Anything that you are doing, when you are directing your mind in anything that you do, when you are shooting a gun, you should have in your mind that the bullet can hit someone. That person is your neighbor. Whether they have a contract with you or not, Lord Atkin is saying that to establish duty of care, the neighbor principle must hold in the sense that anything that you are doing, anybody that you reasonably foresee that my action can harm them is your neighbor. We all now know our neighbors, right? In law, that is neighbor. principle. And anybody who suffers under this condition, you owe them a duty of care. Please, are we okay on duty of care so we can proceed to another case?
Yes,
Yes, sir. Very okay.
Fantastic. There is also the case of Caparo Industries versus Dickman, still on duty of care. And I have seen that on your course outline, so I will just briefly touch on it. In Caparo Industry versus Dickman, in this case, Caparo Industries were going to buy a company called Fidelity. But before you buy a company, as business students, you do your due diligence. And in doing your due diligence, you go and take the audited accounts of the company, right? And see whether the company is in good standing, whether the company has enough financial resources, or whether they do not owe, so that you do not go into a loss. Caparo going to acquire this company, Fidelity. The auditor who prepared the audited accounts of the Fidelity company, his name was Dickman. Dickman prepared the accounts and was careless. He did not put out the comprehensive account of the company to indicate that the company was making losses. At the end of the day, his account indicated that the company was making profits. So what happens? Caparo will sue after buying the company that we wanted to make profit. We relied on this company's the auditor's account to buy the company. We thought that it was profitable. After buying the company and going into the books of the company, we realized that the company was not making profit. They were making losses. So the auditor was careless in preparing the account. So I am suing the auditor in negligence. He has to establish all the three elements. This was a 1990 case. And remember, Donohue was a 1932 case. So this one will bring in new elements. And what was established in the Caparo case was that it is not always every time that anybody at all can come and sue. Then if you open that floodgate, everybody will say somebody has done something wrong to them. So the court in Caparo Industry established new principles to say that there must be proximity. It has to be foreseeable that this person is the one coming to buy the company. And lastly, to impose obligation or liability on the auditor, the court must say it is fair and just. Is it fair? Is it reasonable? Is it just to impose liability on the accountant because he's made a mistake? No. So the court is saying here that we will not go back to say everybody at all is your neighbor. What we will say is that the person who prepared the account, he did not know that you are coming to buy the company. So he should have you in your contemplation. Remember, I have always been saying you should have them in your contemplation. The auditor was preparing the account for the shareholders and the company. I'm sure you already know from your company law that Solomon versus Solomon clearly say that the company is distinct from its members. So the auditor in preparing the account was preparing for the company and the shareholders or members. He did not have Caparo in his contemplation that you will come and buy and rely on my statement. So the only people who can sue is the members and the company itself. So in Caparo Industries, new to say principles were developed: proximity, foreseeability, and is it fair, just to impose liability? That is simply also supporting Donohue, but limiting the liability of the person who has committed the tort. If you have time, kindly read the case of Caparo Industries versus Dickman. By the end of the lecture too, we will have a new position, or you have a proper understanding of what duty of care means. We will not belabor too much on duty of care if we have a very solid understanding of duty of care from now going forward. So we are moving from duty of care. If anybody has a question, we can have it before we move to the second element. Are we fine?
Yeah, we are
Very
very
fine,
fine.
Yes,
sir.
sir.
Yes, sir.
We are very fine.
Okay. We have duty of care. We have mentioned the neighbor principle now. Breach of duty. So we will see the breach of duty. That one is not going to be too detailed because all of us know what a breach is. If you breach, it means that you have done something wrong or you have done something contrary to law or contrary to standards. So when we say a breach of duty, the breach of duty means that I owe Paul or I owe Ni a duty of care, which we all know. But in owing Ni a duty of care, have I breached that duty? It means that there is a standard. Duty of care, we understand. Breach of duty. Let's use this example. There is a standard in doing anything in this world. So your lecturer who is teaching you today, there is a standard that he has to follow a course, a manual. If the lecturer teaches you something that is not in the manual and teaches you something that is wrong, and you go to the exam and you fail, he has breached his duty. If somebody is preparing a drink and before they cover the drink and put it on the market, they do not take care, reasonable care, and there is a pin in the drink, there is a snail in the drink, there is hair in the drink, they have breached a duty. So breach of duty means there is a standard that you have to follow, and that standard has not been followed. Please, are we okay with breach of duty so that it is very easy and like if you are a driver is driving on the road, he has to drive in his lane. If he is sleeping and he drives on the pavement, he has breached his duty. The duty is that the standard is that you drive in your lane. The standard is that if you are driving and you get to a traffic light and it is yellow or red, what do?
You stop.
Stop.
You stop. That is the standard. When you don't stop and you drive through, you have breached your duty. Anybody you hit in that process, you owed them a duty of care. You have established two elements. Are we okay with this?
Yes, sir.
Yes,
Yes,
sir.
sir.
Yes, sir.
Yes.
Right. So breach of duty means there is a standard of care that you have to take in doing something. But if you use all reasonable steps, you are driving, you owe somebody a duty of care. You got your traffic light, you stop. The traffic is green, you set off. You hit someone, you owe them a duty of care, all right, but you did not breach your standard. So when they come in court, it is very unlikely for them to succeed. You are a business person. You produce drinks for sale. All the years that you have produced drinks, you take reasonable steps. You add sugar, you add pepper, you do this, you do that. By the end of the day, your sobolo is ready. You put it on the market for 15 years. You've not had any issue. Somebody goes to take the sobolo. You come out, the person says, when they drank the sobolo, they are feeling very bad. So they have sued you in court. Then they have established that you owe them a duty of care because they have bought. But can they succeed in the second element? No, because you use the right standard. Anybody at all in the sale of sobolo, this is how they prepare it. You go to Burkina Faso, this is how they prepare it. You go to London, this is how they prepare drinks. You come to Ghana, all the companies here, this is how they prepare the drinks. So why is it that the person has gotten sick? Well, they said they drank your sobolo. You owe them a duty of care. Did you breach your duty in preparing the drink? No. But in preparing, one of your workers was sleeping, or you have not paid them for 2 months. So when they were preparing, they added too much pepper beyond what anybody could take. When they tested it, they give the sobolo to a cat. The cat is dead. It means that this particular sobolo, you did not use the standard in preparing sobolo, so you have breached the standard of care. This is the simple understanding of breach of your duty. You did not use the reasonable steps and the standards required in doing something that any reasonable man knows that this is how you prepare something or this is how you do something. So if you establish that, you can also succeed that the person has breached their duty. The last element will be damage. The last element to establish in negligence is damage. Somebody, I'm going to use the Sobolo story again. Somebody has taken your Sobolo. You did not prepare it well. Maybe the pepper was a bit high. They took it. After that, they have come to see you. The court will be asking, what damage did you suffer? You took Sobolo, you said there was pepper. After 20 minutes, the pepper in your mouth is gone, or it was too hot. What did you suffer? What damage did you suffer that you are suing the business? So you get the point. There has to be a damage. Damage in terms of what the person who is saying that you have breached their duty, what the person has suffered in terms of, it can be an economic loss. It can be loss of money. It's not only about a person suffering physical damage. It can be loss of money. It can be anything else. But if you do not suffer any damage, it means that the third element has not been proved, so you won't succeed. Do we get the point here?
Yes, sir.
Yes, sir.
Hello, sir.
Go over again, please.
Hello, sir.
Can I? Okay.
Yes, you can go over again, please.
Hello, sir.
Yeah, I can hear you, please.
Sir, please, sir, you know this company, Mawako.
Yes.
I remember some time ago,
Mm-hmm.
their food that they produced,
Mm-hmm.
some people ate it and they had food poisoning.
Right.
And it was established that
Yes.
indeed the individuals were tested at the hospital that it is food poisoning.
Okay.
Is this an example of damage?
Perfect example. Food poison is dangerous, but they established that. I'm sure if you were a judge in this case, in establishing negligence, from the way you have explained it, you will not struggle to establish all the elements that anybody who enters Mawako is owed a duty of care. One, the person who bought the food from Mawako and ate has suffered because Mawako prepared food that was poisonous. Nobody enters a chop bar or a restaurant to buy food that is poisonous, and nobody prepares food with poison or doesn't make sure that there is no food poison. So they breached their duty. The standard of care was not there. And even in the standard of care, what you do is that you will test the food before you sell. So if you test and it is not too good to sell, you don't give it out. So that from that point, it means that you have established a breach of duty. Then you go to the third element. The people who consume the food, did they suffer damage? Of course. If you take poison, a food that is poisonous, you do not even need medical proof to say that you have suffered damage. Remember the woman in Donoghue versus Stevenson? She went to the hospital. She was treated for a gastro disease from consuming a drink that had a rotten snail. So she established all the principles or all the elements. She suffered damage. So if there is no damage to you, anybody who took Mawako's food that day, they can establish the first two elements. But if it did nothing to them, they cannot prove that this is how much they suffered. They went to hospital. The hospital diagnosed them and said they have poison in their poisonous substances in their blood. They were treated. They were given medicine. All that, they have proved the three elements. Is that clear?
Yes, sir. Yes, sir.
I see Ni Manches hand.
Okay, Obama. So, am I getting the understanding that the damage, when it has to do with health, doesn't need to be proven medically, so that it becomes the basis upon which a ruling is given? I'm asking this question because If it is so, then it leaves so much room for anybody to get up at all any day and say that, no, I took this and I believe the damages I'm suffering is caused by this, which could, in actual fact, not be related to the substance or the article. I think in the cases referred, they use the word article for the article in question. Thank you.
That was me trying to explain the case of the Mawako as such an example. But in law or in court, you prove everything with evidence. That is the simple answer I'll have. You cannot go to court and say, when I took the food, I felt nauseous, or I felt like throwing up. That will not be enough proof. So I'm not saying you do not need medical examination, or you do not need medical proof. But for instance, you cannot also base it on medical proof alone. Somebody has come to you to take food at Mawako. There are 7 or 8 people who have gone to hospital and suffered like that. They have proof. The last person has also suffered the same symptoms that the 6 or 5 of them suffered. What they need to do is to go to the hospital and establish that. Because if they come to court, all the people who have suffered damage as they claim will present evidence. In Donohue versus Stevenson, the proof, hospital receipts, diagnosis by the doctor were all proof. So we do not want to go to a law of evidence to prove that this was right or this was wrong. I was just making an example that when you eat poison, somebody feeds you with poison, or somebody sells poisonous food to you, you do not have to say they have to bring a medical report, of course. In court, that is what will be required. So all what we are saying here has to be proved. Even the breach of duty, even the duty of care, you have to prove that this is what happened. And if it happened, indeed, what is your evidence that it happened? So you have to bring something to show that this is actually happening. You can't go to court and say, what I'm saying is the truth. You have to show by something. So you need a proof. However you develop your proof, whether medical report, whatever, if the court says that your evidence that you are bringing is sufficient enough to establish that damage has been caused to you, so be it. So it cannot always be medical certificate or medical examination. If the court says the proof that you have brought is enough to show that you have suffered damage, the court will grant the claim that you are seeking. Is that fine?
Certainly.
Okay. So this is where we look at the last part of the elements. We are looking at the damages that have been suffered. We cannot go too deep into the damages as they are in law, properly so called, but because in law, the damages can be causation. Who caused it? How relatable was it that something has happened to you? You claim that a duty of care has been was owed to you. That duty has been breached, and you have suffered damage. So they are going to ask you, what damage? How was it caused to you? Was it foreseeable that this thing will be caused to you, or even though we owed you a duty and the duty has been breached, the damage that has been caused to you was not a result of what the two elements has established? There are very interesting cases under under causation and damage. I don't think that we need that for now, but you are establishing all the 3 elements. If there is anybody here who doesn't understand what damage is in law, they can raise their hands up so that we establish that the damage can be monetary loss. Somebody who owes you a duty of care has advised you to do something, then you go and you lose money. It is damage. So don't think of damage as our basic understanding that somebody has damaged you, your physical body, or it can be to your company. So you remember the case of Caparo Industries versus Dickman. The court held that even though Caparo has relied on the auditor's report to buy the company, Caparo cannot sue and succeed against Dickman, the auditor, because the auditor did not owe him a duty. He owed a duty to the members and the company. Are we okay?
Yes, sir.
Yeah, Emmanuel, your hand is up.
Yes, so under the same duty of care, with reference to the case between Alasa Kutokoli versus Moro Hausa. So there was a principle that was applied during the judgment. And I just want a layman understanding, different from, far from the legal understanding. So it was voluntary non-fit injury. So I want the meaning of this in a basic understanding, not to the legal perspective, but the basic understanding.
Okay. Voluntary non-fit injury, in our basic understanding, will mean that to a willing person, there is no harm caused. But this is the last part of the lecture. From damages, we will be going there. So I don't want us to. So the basic understanding is that to a person who has consented to an act, the person cannot claim that they have been damaged or there has been negligence. So we will come to defenses. So it doesn't mean that when you establish all these elements, you will succeed. The person you are bringing the action against will also have a defense. You take a lawyer, they will take a lawyer. They will have their side of story, and you will have your side of story. But I want us to finish with damages. Then we move to the defenses before we end the lecture. I want us to finish very early so we have time to have questions and answers. But in Alasan Kotokoli, there was a defense for the driver. Okay, Steven.
Yes, sir. Good evening. Thank you for the opportunity. Sir, please, there is this story. I heard it. Someone narrated it to me. And the story is a certain man bought a set of musical instruments with some projector and donated it to a church, his church, the church that he attends. And then later on, he informed the leadership that he has stopped the church. And then the gift that he brought to the church, he won them back. And the leaders also said, this is something you've bought for us. We cannot give it back to you. And the man went ahead, deployed some macho men, went to the church auditorium without any permission. They broke everything down, took all the items that belongs to him. He has caused damage to the church. Can the church take him on to court, or the man can still defend himself that these items already or originally belongs to me? This is the whole story, sir.
Okay. Thank you very much for your story, Stephen. But I think this is a different area of thoughts or different area of law altogether. You clearly can see that from your narration, there is no iota of negligence. You can see there is, if you are a lawyer or you are a student lawyer, you are looking at causing damage or causing harm or unlawful entry. You are looking at a whole lot of law. So it doesn't mean that anything anybody does is negligence. We are treating negligence, meaning that you are doing something and you should have somebody in your reasonable contemplation. This one, there are two parties to an action and they have a background. They have a story behind why they are doing that. So it's a different area of law that has nothing to do with negligence at all, to the best of my knowledge. Are we okay?
Please, the reason why I'm asking is that now they cannot use the facility because he has caused a lot of damage there. The light, the Wi-Fi, everything he has scattered everything.
Yes, Stephen, the fact that you cause damage does not mean that there is negligence. Was there a duty of care? Was there a duty of care? We have already said that your actions must bring or converge all the three elements. So it doesn't mean that anytime you cause damage to someone, this what he has done is a criminal law, purely a criminal law action. To the best of my knowledge, it's not tort, it's not criminal. You know, the tortious actions are civil. So this one can even be a criminal law action. I don't think that it has anything to do with negligence, because the damage has been caused, but the damage is not as a result of negligence. He did it knowing very well that there is a history or a background to the whole story. So we may delve into a different realm of law, but not in tort, or specifically not even in negligence. Do you get?
Yes, I'm okay now. Thank you.
Yeah, right. We have 1 or 2 minutes to conclude on damage. Then we look at 2 cases and look at the defenses before we bring the lecture to an end. So I was asking if anybody has an issue on damage. If we all can establish a damage now, that you have suffered an economic loss, you have suffered a personal injury, you have suffered from a property loss, all those things are damage as a result of somebody's negligence, owing you a duty of care, breaching that duty, resulting in the damage. If we are okay, then we can go to the case of Alasan Kotokoli that you have all read. Then we come to Mensah versus Ghana Highway Authority. When you read that case, you realize that Mensah was walking on the Lebanon Road in Cape Coast on a bridge called London Bridge in Cape Coast. The bridge caved in. That the bridge broke when he was walking on. He was a 67-year-old man or so, and he suffered injuries. He went to hospital, had his hospital receipt. He was treated, and then he sued the Ghana Highway Authority, who are the institution mandated to construct and see that bridges and roads in the country are in good shape. He succeeded because he established all the 3 elements. The court said that anybody who is using Ghanaian roads or bridges or anything constructed by an agency, that person is owed what? A duty of care. You make sure that you construct the bridge to the best of standards so that they don't cause damage to anybody who use them. So the Ghana Highway Authority was supposed to know that anybody who uses their roads that they construct is their neighbor. And the neighborhood principle is that when you are doing anything, you should have in your contemplation that anybody who will foreseeably be in proximity of what you are doing is your neighbor, and you owe them a duty of care. So Mensah was walking on a bridge. The bridge broke. He suffered damage. He went to hospital. He had his receipt. He was treated. He sued Ghana Highway Authority. He succeeded in the action. Why? Because he was only walking on the road, the bridge that they constructed. It was found that the bridge was not constructed well. And even if it was constructed well, it was the duty of the Ghana Highway Authority to come to check regularly to see that the bridge is in good shape. That is their standard. So in this case, the claimant succeeded because he proved all. And the company Ghana Highway Authority had no defense. Please, is this a perfect demonstration of negligence as in the law of tort for all of you as you have read the case of Mensah versus Ghana Highway Authority?
Very well. Yeah.
Yes, sir.
Yes,
Perfect.
Yes, sir. Yes, sir.
Okay. So now we will move to, we are the claimants. All of us here from today, when we suffer something, when you go to a cinema, you go to a show, you pay to enter a movie house, or you pay to enter a place to do anything, or you don't even pay. You have gone to an office and then you suffer a damage. The floor is slippery. They have put water there. An office is not supposed to have water on their floor. You slip, you fall, you break your leg, you go to hospital, you pay over 200 300 cedis, you can bring an action to the hospital, to court, and sue the office that you went or the campus that you have established all these three elements under negligence. If they have any defense, they should bring it. If they don't have a defense, you succeed. So anytime you are doing anything, you sit in a car, the driver owes you a duty of care. But the case of Alasa Kotokoli versus Moro Hausa is where we start our defenses. So the next one is defenses to negligence. Defenses means the person you are suing, do they have a defense? It doesn't mean that you go to court, Mawako, I've eaten your food. I've suffered stomach upsets. So I'm bringing an action to court. They have to also mount a defense. Are we good to go?
Yes, sir.
Yes,
Yes,
sir.
sir.
Yes, sir.
So,
Yes, sir.
so the defenses to negligence. The first one that we can establish is contributory negligence. Contributory negligence. So you can write that. Maybe some of you will become defense lawyers in future. So contributory negligence, it means that basically Eunice has admitted that she was negligent in preparing sobolo. There was a feather in the sobolo, obi de takra atu sobolo. But the sobolo is, the bottle is not opaque. The bottle is very open. If you take the bottle of sobolo, you can clearly see that something is in. Or let's say water. You bought water and the water was prepared by Eunice, or the water was prepared by Steven. Steven's company has prepared water. It is clear. Then Laura went to buy water. She has seen that a feather is in the water, but she has heard that negligence in the law of tort means if you do something, you don't do it well, and I suffer damage, I can sue. She clearly can see that takrada bottle no, but wanom and waba court. The law is saying that contributory negligence, also you're negligent, you clearly saw that, unlike Donohue versus Stevenson, where the bottle was opaque, bottle no na enye clear and you them. Laura, dear, you clearly have seen that there is takra in the bottle. And he okokota. Then the defense for the company will come out and say, oh, there was feather. Court and say, where is the takra? What the about court? So this takra is in a bottle of water. You are not blind. You did not see. Because you want to come to court, you are here. No, we have a defense, and the defense is called contributory negligence. It means you will not succeed. Even if you succeed, kebema 1,000 cedis, kebema 200 per, because who said takra them and wash it down one and waba court. Please, do we understand contributory negligence?
Yes, sir.
Yeah, very clear.
Yes, sir.
Very well.
Yes, sir.
Yes, sir.
Contributory negligence. The case of Alasa Kotokoli will come. Our brother earlier mentioned volunti non fit injuria. In Latin, it means that you voluntarily assumed a risk. Alasa Kotokoli, you have gone to your farm. You are coming back. You have seen a timber car, akofendia. There is only one seat for the driver and a small seat for the mates. Obi awatere kurasi bia, you know, say timber car, they don't have seats. And the driver stopped. We say, oh, he was in Achimoda area. Oh, I'm going to my house from the farm. I'm tired. The driver stopped. In the village, they will stop and pick you. And now we got na timber car, so baby, it is not a seat. It is where they put their toolbox. The timber car driver, they put their toolbox. If the timber breaks down, they will come and fix. But you want to get home early. So Alasa Kotokoli has gone to sit on the timber track. There's no seat. Where he was sitting, it was risky, but he wants to get home early. And then the timber car hit a pothole and it jumped him. He fell, his leg was cut, he was amputated. He brought an action, said the driver was driving recklessly and the car hit a pothole. As to whether the driver was driving recklessly or not, the court is saying that this is contributory negligence, Alasa. You will not succeed because it is voluntary non-fit injuria to a voluntary action, to a voluntary risk that you assume. The law will not come to your advantage. You see a timber car, then you go and sit at the back of a timber car. There's no seat. So the moment he stopped, no one can and say, oh, seat any dia monko, but be a make what nano, timber no crabbe me abome. Then you know that okay, you have not been negligent or yourself. So voluntary non-fit injuria is an aspect of contributory negligence. So my brother who asked, this will not go for the person who come to court. It will go for the person who is defending the action. So if you are a lawyer or if you are a business person, I've given you the example of water, that there is a rock, a stone in the water bottle. You can see that this stone there, any reasonable person, court, they deal with reasonable people. Just say you come and say, I'm mad. Any reasonable person will see that this stone is too big for you to drink into your stomach. The moment that you have drank this stone into your stomach and say, I did not see it, it means that contributorily, you also contribute to the negligence. So you will not succeed. If a timber car is going, somebody is driving a boboya, you want to get home, you stop him. Oh, aboboya driver, take me home. Aboboya no afa bola. There is no seat. Then you have gone to sit on top of the plywood and bola. Aboboya hits the pothole. It jumps. It throws you into a gutter. Your leg is broken. You see, oh, I learned negligence. The driver was driving bad. He owes me a duty of care. He's breached his duty. I've suffered damage. The court is asking, aboboya ye defa nipa. Then you say no. But out now, any reasonable person will sit there, you say no. You are like Alasa Kotokoli. Edu J, the judge who sat on the case, said if you bring sympathy into the law court, then everybody will come and take money and go. You don't go to court and say you have sympathy. Oh, Alasa Kotokoli, they have cut his leg. He sat on a timber car. And so the judge is crying. Oh, I feel for this man. He's coming to court with clutches. He has no leg. No, you contributed to what you have suffered. Voluntary non-fit injuria. You have suffered, but you were contributory to that suffering. You have assumed a risk. There is a very popular case. Those of you who have friends who drink alcohol, you and your friend have gone to the bar. Your friend is taking alcohol. The case is, I think it's Owens versus Primwell. Owens versus Primwell. You and your friend have gone to the nightclub. You have drank 7 bottles of beer. Your friend is drunk. You are drunk. Then you are encouraging him, Charlie, drink more, drink more, drink more. You come to sit in the car. Your friend that you have encouraged him to drink and you have also drunk, he's the one driving. He goes to crash the car. Then you come to court and say he owe you a duty of care. The court is saying that you saw him drinking. You encourage him to drink. Or the car na with your paya. You want to come to court. You will not succeed. Contributory negligence is a defense for the person you are bringing the action against. Please, are we okay?
Yes, sir.
Yes,
Yes,
sir.
sir.
You are very okay.
Jackson.
I love this lecture.
Somebody is, your hand was up.
Yeah, sir, it's me. So with regards to what you were saying, I wanted to contribute, and it was a statement from
Yes.
the judge. Under
Okay.
the case of Alasa versus the Moro. Alasa versus Alasa Kutokuli versus Moro Hausa. So the judge made a statement that everyone can feel sympathy for Mr. Kutokoli, but the court's job is to apply the law without letting emotion get away. letting emotion get it away. And it is a stark reminder of legal responsibility that built on principle and not feelings. So it was just a contribution that I wanted to make with regards to what you were saying.
Thank you very much. I think if you read the cases, they are very, very interesting. And that is on what basis you will stand, whether you are bringing an action or you are defending an action. So volunteering unfit injuria, I'm sure that we all know contributory negligence. There is also consent. Consent. So if somebody is doing something to you, there is a case that's it's a very popular case, but not too much of a business wise. So if you are a lady and then you go to have consensual sex.
Hello, sir.
Yeah.
Sorry, is it the second part of defense consent?
Yes,
yes. Of the
we can hear you.
Consent.
Okay.
Can somebody explain to me what they understand by consent? I have consented to what you are.
Yeah, Obama, this is
The meaning you've agreed to.
Agreed.
or in agreement or approval of.
Yes.
Yes, sir.
Okay. So that's exactly it. You have approved of what the person is doing. So in terms of consent, you can bring an action for negligence. But if you have consented, there is a case where a lady had consensual sex with a guy, and then the lady suffered from infections, and they brought an action that the guy was negligent in doing all that to her, and the court said that this was consent. If you go in, when they give you money, you accept. He send you momo, you accept. Come home, you come, and then you have come and have sex. You have enjoyed, but then you want to take one out. That's this one that he has given me there. I don't want it. If you consent, you cannot come and say, so the ladies, this is a defense in law that consent. Somebody is doing something to you. You clearly see that I can say stop. You are encouraging them to do. You are on bed. The person is doing something. You can't tell them, oh, please wear a condom. You have enjoyed yourself. You didn't say all that. You consented to what they are doing. Then tomorrow you come and say, oh, this one there, I have to bring an action for negligence because the guy did not protect him. You too, you did not protect yourself. But you take everything. If you take momo, you will take the infection. The court will say, once you take the momo, you take the infection too. So consent is a defense in negligence. That's anything that you go and say, I have accepted, I have consented to this. So if consent is successfully proved, a complete defense, the guy will walk out of the court free. Like you go to a bar, the owner says, oh, so bolo way, pepe woman no too much. And ramenum be cry man to me and that. Menom, oh, I'll drink me and pepper there. It's like the lizard. Me, I can eat all pepper. You would finish and you say negligence. The court will say you consented, you were aware. It's a complete defense. And the consent has to be unambiguous. So if you are in law or you have a business and this thing happens, it has to be unambiguous. The person should not come and say, Pepe wom, what's a kakra? Or say, my man try and share no or no more. It's not ambiguous. It has to be unambiguous. He's drinking and say, oh, Pepe ne do so pow. Or say, oh, me. No, this watch it. The shit is too much. Oh, please, you can't eat. Oh, I'll eat. Please stop. You can't eat. If the person eats it, he has consented. But it doesn't mean, oh, he asks you, Pepe will say, has a kakra. It's not too clear. So the consent has to be unambiguous, clear, so that you go to court. They will ask him, or catch you say, watching the shit on, I know pa. You said yes. And when you were taking it, he told you that somebody has taken it. The person's head is aching since yesterday. You said, oh, yes. He told you that You even said that you are more like a lizard. You can eat all pepper. He said, yes, my Lord, I said it. Oh, you consented. So you will not succeed, even though the person owed you a duty of care. They have breached their duty in terms of preparing shit for normal, reasonable human being. You have suffered damage. Your tongue is aching. But you cannot come to court and say the person should do this or that because you are suffering. You consented to the action. So this is one of the areas that the defense team or the person that the action has been brought against will succeed, or the person that the action has been brought against will go to court and say, one, we have contributory negligence. Contributory negligence, and I had to add, please, the new position is that they will look at the contribution that you suffered. If you contributed to the damage you suffered, they will calculate. Sometimes they can give you maybe I hope 10,000 cedis damage. Then they will say, oh, damage is how open 300 cedis per because one kasana you contributed. Sometimes they will give you nothing. So this is one of the areas that you can tackle. I think we have two defenses, that is contributory negligence, and we also have mentioned consent. And sometimes you can use the voluntary non-fit injuria as a separate one. The next one that I want to mention before we end the lecture is illegality. Illegality.
Sir, please, I want to ask one question before we move on. I don't know if I will be allowed to do so.
Oh, yes. We will end very soon, so you can.
Okay. Please, I want to ask this question with regards to this Russian guy who came to Ghana and then messed up with our ladies. Can he also defend himself? Because maybe the ladies were not aware that after having an affair with this guy, the guy is going to post them or post the videos on social media. Maybe that one wasn't part of the agreement. So on this case,
I think it's a completely different scenario because I understand you perfectly, but posting people's private videos or sexual affair in public is a breach. It's against the laws of privacy in terms of Electronic Transactions Acts and other enactments or other laws that you cannot, and data protection and all that. So people's privacy should be protected. That one is a different law altogether. But if they bring an action in negligence, I don't know how they will succeed because the sex was consent. And what damage have they suffered? Posting their picture online will not be a tort. It's a criminal action. So you cannot bring it under negligence at all. But it's a breach of their rights that he posted their images online. Please, are we clear?
Yes, sir. Very clear. Thank you.
Yes, sir.
Okay. So let me go on with illegality. So in law, there is a saying that exterpi causa non orata actio in Latin, which means that a person cannot be allowed to profit or benefit from their illegal act. Exterpi causa. You don't need to know that, but it's a legal principle that, like somebody mentioned, voluntary non-fit injuria. If you go to court, you hear a lot of this Latin phrases and Latin expressions very much. So you are an armed robber. You have jumped into somebody's house to go and steal. Once you jumped into the house, a dog which has not been chained come to bite your leg and causes a lot of damage to your body. Then you are in court to see that the person owed you a duty of care, they have breached their duty, you have suffered damage. That was the case of Cummins versus Granger. You don't need the case, but you just need to understand the principle. You now, you are an armed robber. Who are chrome for clear? You have jumped into somebody's house. A dog has bitten you. See, they should have chained their dog. The dog was not chained and was not trained, and the dog has eaten you, so you are coming to court for negligence. The thing that you are going to do is an illegal act already. So you cannot succeed in court. There's no way you you are going to steal. The police is chasing you. And as the police is chasing you, are in court say that the police chasing you. In court, there's a case like that, Velono versus Chief Constable of Greater Manchester. The white, they will be seeing on this. An armed robber that they are chasing you. Then you jump from a building, your leg will break. Then you go and sue that, oh, this one, the negligence, the way they chased you, there was negligence. The court will say that the thing that you were doing is illegal. So right now, if you set up a galamsey site, you set up a galamsey site and somebody go there and they fall in a pit. Do you know why the people who are falling in the pit in the galamsey site, they are not suing? Because of this defense. So take it at the back of your mind. If you have a galamsey site, you are a business person, you are doing something illegal, and somebody has come there to do galamsey, they have fallen into your pit. But omo fallen, omukuta matok, omukuta the enema idea galamsey, ekuta no na washe insuo no na oh. You know, no to court to come and say negligence. You have dug a pit and you did not cover it. Because on one case, so he is engaged in an illegal act. So it's a defense for the person who dug the pit. You may not succeed from an act that is illegal. Voluntary non-fit injuria is there. And there is ex terpi causa non aurita actio. A person will not be allowed to succeed from their illegal activity. Only will be able to and now, oh yeah, dear, and papa, you clearly see that this thing that I'm doing, it is against the law. You are having sex with a minor, and the minor has inflicted you with a sickness. Then you go to court. What you are doing is an illegal act already. You get it. In business, there is a lot. You have gone to port. You are under declaring the things that you are buying. Then the container that they are supposed to bring it out, because you said your things are 40 kilogram, you have under declared. They have given you a car that is supposed to carry a good of 40 kilogram, but your goods is 150 kilograms. So when they were bringing it, the things fell. All your plates have broken down. Then you go to court. You have under declared that your things were 40 kilograms, but they were 150. And a port for no amount car for 140 kilograms. So you will not come to court. You are engaged in an illegal act. And ex terpi causa non aurita actio, you will not be allowed to benefit from your illegal activity. There are so many defenses in there, but I don't want us to go in. Too many of them are very legalist. They are too much of law. So I will end here and then touch briefly, maybe 1 minute, on economic loss. I see that also, that we have to treat economic loss. That's in terms of trade, revenue, and resultant damage. The key concept is that if a business suffers or you suffer a loss, generally, there are two losses. There is economic loss and there is a consequential loss. Economic loss and consequential loss. The economic loss is people will come and say, he did something, he poured water in my shop. Tomorrow I would have gotten profit of 500 cedis. And so I'm suing for the profit. The courts are very reluctant. Or more few. Generally, they will not allow you profit. Nobody can calculate how much profit you get from your shop because somebody has locked your goods up or was negligent. But if you are able to establish that, oh, obi abeshe o shop no, the machine that you use in pounding fufu, every day you pound fufu 20 bowls, you can establish that. The court will allow you to succeed because you know that every day you pound fufu averagely 20 plates, and the person has made sure that was say negligently. So after establishing all the elements, then you can say every day I'll pound fufu 20 plates. I need the money from that, but not the profit on the fufu. So economic loss and the consequential loss, this is where the law draws the line. So you can go to court and say that my shop was not opened. Every day I sell around 20 cartons of drinks. The lack of me or my inability to open the shop was as a result of a car that has driven into the shop and spoiled my goods. They will pay for the goods that they spoiled. The shop that you didn't open, how much you sell every day, the court can calculate that. But they cannot calculate the profit that you say, oh, tomorrow I would have gotten profit of this. No. So difference between economic loss and consequential loss, I will entreat you to read on that in terms of trade and the damage that is connected to it. I'm sure we have covered a lot of the cases, and we will not be able to go over. Before, it's a business class, but I will say you have to read a lot of the cases to be able to understand the law of negligence, especially in terms of business, those that come with business, so that you will appreciate your course very much. So we'll end here and then draw the curtain down. If there are no questions, we can leave. But if there are questions, we will have 1 or 2 minutes to answer them. Thank you very much.
Thank you, sir. Thank
You
you.
are welcome, sir. Thank you.
Thank you,
Thank
sir.
you.
Thank you, sir.
Welcome, sir.
Okay,
Hello,
okay.
Obama.
Yeah, hello.
Yeah. So, colleagues, is there any question? If there is no question, I would like to, give a word of thanks to our visiting lecturer.
Okay, Michael, go ahead then.
Go ahead.
Okay. So, on behalf of my colleagues and the entire class, I would like to express our profound gratitude to our visiting lecturer, Sadiq Adams, alias Sports Obama, for the insightful discussion he's had with us this afternoon. Taking off time from your busy schedule to be with us and share with us your knowledge and practical things that has to do with business law and, for that matter, tort law, is really encouraging. And I want to say that we are very, very grateful for your time. Obama, we hope to see you again as Doc deems it fit and necessary, as and when it becomes necessary. So once again, Obama, we say a very big thank you for, the lecture this day. It has enlightened us the more, and then the understanding has become, clearer with it. The simplicity with which you did it is worth commending. So, Obama, we want to say thank you and God richly bless you. On a lighter note, the sheep dealer should be very proud of you as his boy.
You will
Thank
come
you.
after him. You will come after him today. You will
Thank
come
you
after
very
him
much.
today.
Okay, okay. All right, thank you, Michael. Thank you, Michael, for that. And
we didn't see your face, so
Senior, Mr. Adams, thank you very much. And just as the Michael has said, I'm very sure that the whole class has enjoyed the lesson. I was expecting that we write down notes. So, and because after this, and from how Mr. Adams has taken us through the principles of negligence, supported by relevant examples, including enhancing our understanding of the subject. He has also gone through all the cases, so I don't expect that you'll be expecting me to give further notes. You are expected to read further on the cases. If you have questions, further questions, maybe next week when we meet, you bring them forth. But we are grateful, Mr. Adams. We really appreciate your time. You guys, you don't know how busy he is. And then on a Sunday like this, when he's resting or maybe doing other things, you just keep all aside and then come and then have this 2 hours class or 2 hour class with us. We appreciate the insight you've given us on this topic. God bless you so much. We'll meet again very soon. Please, class. So that will be the end of our lesson today. Hopefully, if we are able to meet on Thursday, I will communicate that with the class reps so that you prepare for that. But in the meantime, I'll be sending you notes concerning our next class. From the outline, we'll be going into company law. So we'll start with company. We'll start with incorporation, how to incorporate a business in Ghana. So please watch out for that. I'll send the notes and some cases to the class reps to be handed over to you. Emmanuel, your hand is up. Is there a question or
Yes, sir. So I was saying we have like 16 minutes, and if you would do us the favor by, giving us the formalities of how to answer the question as you promised.
Oh, don't worry, don't worry. I think we've had a very exciting day, and
Yes, sir. But
just let me give you the time for you to reflect on the things that have been said today. You see, you
Yes, sir,
understand?
that's fine.
Yes, sir, that's
So
fine.
yeah,
Yeah,
yeah, yeah.
another time.
So
Another
when I'm
time.
pulling you,
Emmanuel,
another time,
relax,
so another time when
relax.
I'm pulling you, another time when I'm pulling you, then it means that you guys have taken my 16 minutes today.
We don't complain.
You will not complain because you are taking my 16 minutes today. But all thanks to our guest lecturer, because from what he has done, there's no way I will have to add something else, or I mean, give you other information to
That is
to
it.
understand it. So please just go into the sober of yourself and then reflect on the day, so that we'll meet probably Thursday or next week Sunday. Is that okay?
Okay, so thank you
Next week Sunday is
Very okay.
Easter.
for bringing me.
So okay, if that's so, then we'll meet before the Easter.
Okay.
Okay, sir.
Okay.
So are we breaking?
Yes,
no,
please.
no.
Yeah, it's a break.
Thank you and bye. Bye.
Okay.
Bye.
Thank you very much.
Thank you, sir.
Bye.
And I appoint them munya mujan in them.
What do you know there?
Oh, that's a car.
You,
Bye bye.
you, Eunice.